Seeing none, that is introduced. Sure you don't have more, because we're approaching 600, and I promised the clerk up there we'd hit 600 this year. So anyhow, that's all. And, do you have?
So was that a challenge?
No, not really. You'll have to bribe Jason for that one. Any other bill introductions, committee? Seeing none, thank you very much. We're going to then open our confirmation hearing on Jordan Massey, who's our State Civil Service Board nominee. And before we get to that, I'd like Jason to just remind us what the Civil Service Board does, just so we're clear on that.
Yes, Mr. Chairman, members of the committee, real briefly, the Civil Service Board is a 5-member body that hears appeals from classified state employees with permanent status under the Civil Service Act. Generally, the bulk of their hearings are employees who have been dismissed or demoted or suspended, and they're appealing that decision on the grounds for that decision, as they are entitled to do so under Civil Service Act, to the Civil Service Board. It's within the Department of Administration, handles these appeals from these employees, has a hearing process. It's all laid out in the Kansas Civil Service Act, but that's what the Civil Service Board does.
Thank you, Jason. Committee, any questions? Seeing none, I think we're good. This morning we have Jordan Massey here, who is our nominee, and if you'd like to make a statement, and then we'll open it up to questions for the committee. Jordan.
Sounds good. Thank you. Thank you, Mr. Chairman, Vice Chair, ranking members, and members of the committee for the opportunity to appear before you in support of my appointment to the State Civil Service Board. My name is Jordan Massey, but most call me Joe. It's a nickname that I picked up while playing soccer on the inaugural Fort Hays State women's team back in 2011 when I first moved from Colorado to Kansas. During the tenure at Fort Hays, I had the pleasure of earning my bachelor's degree in international business and economics, and I served as the soccer team co-captain both my junior and senior years. In 2017, I opted to continue my education by attending Washburn University School of Law on a full tuition scholarship. The Ichabods were a conference rival that I was well familiar with. While at Washburn, I participated in the law school student body association as an elected class representative. I represented the school at a mock trial competition in Chicago, and I focused my legal studies on labor and employment law. I graduated with Dean's Honors in the infamous COVID class of 2020, and I passed the Kansas bar the same year. Since graduation, I've had the pleasure of representing injured workers, injured Kansans in their workers' compensation claims while working for Slape and Howard in Wichita. Those claims fall under the Department of Labor's administrative proceedings, and my practice includes attending preliminary and/or regular hearings nearly every week to advocate for those not receiving benefits that they're entitled to under the law. I'm proud to say I've helped over 300 Kansans gain access to benefits that insurance companies had wrongfully denied. I like to think that a portion of my practice includes maintaining the integrity of the workers' compensation system by analyzing and educating those who are making a claim for benefits that might be questionable under the law. My exposure to that gives me a unique perspective into motivations and aspirations for those asserting their rights to benefits, which I think will aid me in serving in this board. Likewise, I've been tapped as my firm's primary brief writer, thanks to my attention to detail and my ability to provide sound legal analysis. I'm a member of the Kansas Trial Lawyers Association, where I serve as a member of their finance committee, a member of their new trial lawyers section committee, aiding attorneys in practice for less than 10 years, and their amicus committee, drafting amicus appellate briefs in support of legal positions justly protecting injured Kansans. As a member of the State Civil Service Board, I look forward to continuing Kansas's long tradition of fair due process in adjudicating grievances within the bounds of the law. I appreciate your consideration in my appointment and welcome any questions you may have. Thank you.
Thank you, Joe. Committee, any questions for Ms. Massey? Senator Fausto.
Thank you, Mr. Chairman. Ms. Massey, so you mentioned Slape and Howard in Wichita. Are you still with them? And then my second question, Mr. Chairman, is, so for this position, did someone approach you, or did you just boldly apply? Thank you, Mr. Chairman.
Thank you, Senator. I am still with Slape and Howard. I am working on a partnership which should be completed at the end of the year. I was originally approached by Mr. John Polzar, who is a lobbyist for the Kansas Trial Lawyers Association. He had mentioned that there was an opening on this board in our district and was encouraging younger attorneys to apply, which is why I threw my name in the hat.
Committee, any other questions? Senator Straub.
Thank you, Mr. Chair, and thank you, Ms. Massey, for being here today. I see that you had worked as a clerk for the Kansas Association of Counties, and could you give us an example of something that you learned, like maybe a surprising portion of the law that affects counties and not municipalities, or something to that nature?
Sure, and thank you for the question, Senator. I had the pleasure of working on a Supreme Court appeal regarding the Board of Tax Appeals for unused, they were unused oil rigs and how that was taxed when they're not in use versus when they are in use. And the interplay between the different committees, the different government sections working on it at different times, I think is what really intrigued me in moving more towards getting into the government side of things. Really understanding how the Board of Tax Appeals, was allowed to make decisions, and then under what circumstances they would assert their jurisdiction versus not. I think that was a really cool process to learn, and how all of the stakeholders in that decision could really come together and come up with a solution that I think was beneficial for everyone.
Any other questions, committee? Oh, do you follow up, Senator Straub? Sorry about that.
Thank you, Mr. Chair. Not really a follow-up, although I am familiar with oil rigs, and they're taxed in the county that they are located in, I believe, on January 1st of the year, correct?
Correct.
And we haven't changed that, though, have we?
I don't think so, no.
Okay.
Not that I know of. Unfortunately, I haven't followed up with it much after I left the Association of Counties in 2020 after graduating.
Thank you. And my other question is, I see there that you had provided testimony to, I believe, the federal delegation about the restriction of the use of TikTok at the federal level. And I see that you have an Instagram and a Facebook. So could you give us kind of your personal opinion on the differences between them, and should we have restriction of speech on any of those platforms?
Thank you, Senator. That's a good question. Yeah, I had actually reached out regarding that legislation because I am of the opinion that the people have the ability to dissect information the way that needs to be dissected, meaning that the more access to information, I think, the better, and allowing people to have the access and ability to make their own decisions without restricting their access to information in order to make those decisions is important. I also am of the impression that the way that we are gaining access to information nowadays is shifting away from the traditional sources of information and media. And I think limiting access to the new forms of media only puts a hindrance on people's ability to access information and make informed decisions.
Follow up, and then Senator Blasey next. Yep.
Thank you, Mr. Chair. So, for example, if Facebook were to use an algorithm to stop a certain post from appearing on as many other pages or in as many other feeds, I'm co-sponsor of a social media censorship bill. So, just kind of want to get your stance on that.
Yeah, good question. I think access to information is important. I think trusting the public to dissect that information and use it to make informed decisions is important. I think that's kind of how the process is intended to work. And so I think limiting restriction to access to information is a fine line to draw, but protecting people from misinformation is something that could probably be beneficial. I think it's just deciding who is the arbitrator of what is information versus misinformation, I think, can get a little bit skewed. And so allowing people access to information and allowing them to be the ones making informed decisions, I think, is where my stance would fall on that.
Senator Blasey?
Thank you, Mr. Chairman. I want to thank you for your willingness to continue to pursue how to, in public service as a young attorney, we're looking to give back to your community and your state. I do have a question, and I don't know if it's probably for you or if it's more for the governor's office. I see you're filling a term that's actually in the middle of a 4-year term, and so I'm curious if, do you know, did Crystal Career, did she resign? Did she
Unfortunately, I don't know. Thank you for the question, Senator. Unfortunately, I don't know the circumstances surrounding the opening on the board.
Okay, and I'm sure the governor's office is watching, so they can get to me on that. And then the last question I would have is, I guess for the governor's office, is there's a term on here that expired a year ago, and I'm curious if there's an appointee for that spot. And so maybe I was wondering if you were meant to be appointed to that slot. So anyway, it's not for you, but it's for the governor's office. Thank you, Mr. Chairman.
Okay. And Elena, if we could find out the answer to those 2 questions, please, and let Sheila know, and she could email it to the entire committee. Committee, any other questions? I just have one, kind of the follow-up on the TikTok. When do you remember about when it was that you had sent that your opinion on the TikTok situation? Was it a year or 2 ago, or?
Yes, thank you, Senator, for the question. I believe it was when Senator Moran had initially introduced his legislation federally to kind of, really my problem with the legislation itself was that they were appointing a single unelected official to be determinative of what type of censorship would apply to the information. And so that's where I said, hey, I think that is a little bit overstepping. I think that's a little bit of a government overreach.
And since you will be handling government people who have clearances, have you since learned about the concern from, what is it, CFIUS, I believe, about TikTok's bad action because they are a Chinese-owned company and may be spying on Americans? Have you since learned about that, and does that change your mind about that situation at all?
I appreciate the follow-up question, Senator. I have not done too much research into any alleged allegations against TikTok. However, my primary concern with the bill was that it was putting the power to disseminate that information into the hands of one unelected official. And I think that was where I saw that as a government overreach. I think it's important for people to have access to information, and I think trusting the public to disseminate that information is an important part of this process.
One last question then. If you were, and I don't know if we can ask specific questions like this or not, and Jason could guide me on that, but if you were reviewing a situation where a particular employee had an appeal because they were demoted or let go because they had engaged in information on social media that might compromise government information, how would you deal with that? Because that seems to conflict with your personal beliefs. And reviewing someone's employee status, to me, you have to be objective. And so if we have information, and we do, that indicates that those, particularly TikTok, is a potentially dangerous platform, could you be objective, and how would you resolve that personal conflict?
Yes, thank you, Senator. Fortunately, I have the ability to separate my personal beliefs from when I need to apply the law to the set of facts. And if an employee in your hypothetical is violating a policy that is clearly delineated in their employment policy book, that is something that I can consider. And as long as it follows an already predetermined expectation of what the employee was supposed to be behaving, and if they acted outside of that behavior, it's a situation where I can apply the law to the facts, and I can be objective about that.
Any other questions, committee? Seeing none, thank you, Joe. I appreciate it. We will close the confirmation hearing on Ms. Massey, and let's reminder to the committee to turn your packets into Sheila, and we will consider the appointment on another day. We'll now open our hearing on Senate Bill 523, clarifying the eligibility requirements to obtain a license for conceal and carry. And I'll have Jason step forward and give us a brief on Senate Bill 523.
Thank you, Mr. Chairman, members of the committee. Senate Bill 523 makes some amendments to the Personal and Family Protection Act. This is the act that governs and regulates carrying a concealed handgun in the state of Kansas. The amendments generally update the eligibility provisions with respect to individuals who are ineligible to obtain a concealed carry license due to certain criminal offenses that they've been convicted of. Additionally, the bill directs the license holder to surrender their license if it has been suspended or revoked by the Attorney General. So first off, the bill you'll see on page 1, 75-7004 is the eligibility statute under the act. And this is updating those offenses. Mainly, the bill would remove offenses that are related to possession on school property and replace them with offenses that more mirror the federal prohibitions for firearm possession. Those are if you're a fugitive from the law, if you're an illegal alien in the United States, if you're subject to a protection from abuse order, or you've been convicted of a domestic violence offense, you're prohibited under federal law. And those new references in line 17 would capture the state law equivalent that we have in KSA 21-6301, which is our criminal firearms statute. And then the bill also adds the offense of unlawfully possessing a concealed firearm. There is a criminal statute that makes certain instances of concealed carry unlawful, and if you're convicted of one of those offenses, you would be ineligible to obtain a license to carry a concealed handgun. The other amendment you will see on page 3, this is to the actual issuance or denial of a license or renewal of a license. There's some cleanup language in there, but primarily lines 32 through 37 direct the license holder to surrender their license to the Attorney General if it's been suspended or revoked. If it's simply suspended, then the Attorney General would return the license to the individual upon completion of that suspension period. These changes would go into effect on July 1st of this year if enacted, and I'm happy to stand for any questions.
Thank you, Jason. Question, Senator Reichman.
Thank you very much, Mr. Chairman, and thank you for sharing this information. I guess my question is, this may come from my Attorney General's office, may be able to answer this. Do we have quite a few people that are in violation of this, why we have to bring this bill forward? Do you have any idea on that? Thank you.
My understanding is the amendments are on page 1 are simply to update those references based on changes that were made to the criminal possession statute over the last few years. I mean, I'll defer to the Attorney General's office since they've requested the bill, but that appears to be the intent of those amendments. And the second amendment, I think, is simply to clarify that the license holder must surrender their license upon suspension or revocation. And again, I'll defer to the AG to clarify why they've requested this bill.
Any other questions, committee? Seeing none, thank you, Jason. Our single proponent oral testimony comes from the Attorney General's office, and Robert Hutchinson is going to provide us testimony. Robert?
Good morning, Mr. Chair, members of the committee. Thank you for having me this morning. I don't have a lot of additional explanation to provide on top of what the revisor's office already said. I will note I did inadvertently leave out one citation in the history. Some of the changes that numbers or offenses got added in actually came back in 2018 in House Bill 2145. Those were the changes to 216301. So I just wanted to make sure you had the full picture there. But as stated, what we're trying to do is clean up the citations in the Family and Personal Protection Act so that the offenses they referenced before or that they need to include as prohibited offenses are consistent with how they're actually numbered in our statutes, and so that it's consistent with the federal requirements and prohibitions that are also in place. As far as the surrender of the license, when your driver's license is suspended, you're supposed to physically surrender that card. And we wanted to have the same rule in place for the concealed carry to make sure there's no misuse during that suspended or revocation period. And I'm happy to answer any questions.
Seems pretty simple. Any questions? Senator Falscadeau.
Thank you, Mr. Chairman, and Mr. Hutchison, good to see you again. On this handout from the revisor's office, where it says the bill would remove the offenses related to possession on school property and replace them with offenses that mirror the federal side. So exactly explain the federal position on that, and then
Mr. Chair, Senator Falscadeau, it is also good to see you again this week. The offenses listed in, I think it's A11 and A12 right now, those are the school offenses. Those don't match the federal gun prohibitions, and so we didn't want to be over-inclusive where we didn't have to, and they're not otherwise prohibitive in our law for carrying, so we wanted to make sure those couldn't be considered to be potentially prohibitive for the issuance of a license. And A15 through A18 were added, has new offenses in the 2018 bill I referenced, HB 2145. So we wanted to make sure they were also included under state law. There hasn't been a gap in terms of our issuing or denial practice in that time because they've generally been included. If they're prohibited offensive under our law, they've generally been included in the federal side. We just don't want to rely on the federal law and possible changes there. We'd rather have it clearly codified in our own law.
Senator Falscadeau.
And thank you, Mr. Chairman. And then when one would surrender their license for these reasons, what's that process? How would they do that? Mail it in, bring it in, just give it to an officer or what?
Mr. Chair, Senator Falscadeau, mailing or physically surrendering it would be acceptable, and we could hold it in our concealed carry office. We'd hold it just the same we do with all the other confidential information that we have on hand, and we would pay attention to when suspension periods would end and make sure we return that promptly to the holder.
You could take it to the sheriff's office if you wanted to, or something like that.
I believe we could work that out with the sheriff's office. We work with them on background checks and things like that. So I would expect that any surrender like that would be effective.
Thank you. Senator Straub.
Thank you, Mr. Chair. I guess I think I understand that this bill pertains to those license cards or paper licenses for concealed carry. But on page 3 of the bill, we're down line 21 where it says where a restraining order is issued that would prohibit the issuance of a license. What if they don't have a concealed carry license, but in Kansas you can still conceal carry? Is a restraining order a reason that would prohibit somebody from concealed carrying in general? Or does somebody have to be convicted of a crime in order to revoke those possession of a firearm privileges?
Mr. Chair, Senator, I'm not specifically familiar with any limits on what we call constitutional carry. We were just focusing here, and I think this is actually revisor's cleanup language, to make sure folks that have a physical license from us and the rights that entail, when there's a restraining order, then they have to notify us. So this wouldn't apply to anyone who doesn't have a concealed carry.
Jason, do you have any clarifying information on that? I'll give you a second to, yeah, there we go.
Mr. Chairman, members of the committee, the criminal statute 21-6301A17 prohibits possessing any firearm by a person while such person is subject to a court order that was issued after a hearing and the person's opportunity to participate that restrains the person from harassing, stalking, or threatening an intimate partner or child of an intimate partner, et cetera. So if you are subject to a restraining order, you are prohibited from possessing a firearm under 21-6301.
That would be either conceal and carry or open carry, correct? Constitutional carry.
Just a minute.
I know, we're digging deep into the statutes here.
Mr. Chair, if I may, while he's looking, just the notification provisions in there wouldn't apply just because there's a court order. It would be because of a court order for someone with a license that we oversee. So that's why it involves notification to us.
That appears to be the case, concealed or otherwise, Mr. Chairman. I will update the committee if I see other information.
Okay, thanks, Jason. Any other questions? Seeing none, thank you, Robert. Appreciate your time.
Thank you very much.
Committee, we have one neutral oral testimony provided by Nicholas Reinecker. Nicholas.
Thank you, Mr. Chairman, members of the committee, for allowing me to speak today. My name is Nicholas Reinecker from Inman, Kansas. Just neutral to this because I understand we need to have some sort of regulations on the books, but the problem that I specifically have is in section 1, little a 2, where it says is prohibited from shipping, transporting, possessing, or receiving a firearm or ammunition under 18 U.S. Code 922G or N, which would involve users or addicted to controlled substances. And it doesn't specify use, it doesn't specify being under the influence, it just specifies use. And as you know, cannabis is one of those substances that people are talking about getting off their Controlled Substances Act, and Missouri is one of those states that has done that. So I guess my question and concern is that if the ATF decides that anybody with a DSM diagnosis of, say, like simple anxiety or depression or something like that, what if they decide that that is something that should be a factor in prohibiting firearm possession from somebody? So just some things to think about, and kind of just reining in the federal government and making sure that we are doing states' rights, the 10th Amendment appropriately to all things consistently on a consistent basis. And that's really all I'm asking for. I won't go into any other commentary about entanglement to other issues, except to point out on one of my the Congressional Research Service Controlled Substances Act, it is interesting to note in this vein that on page 3 of that, it mentions that some recreational drugs are not classified as federal controlled substances. Alcohol and tobacco, which might otherwise qualify as drugs potentially warranting control under the Controlled Substances Act, are explicitly excluded from the scope of the act, as in hemp, but we won't get into those ancillary issues. So I just ask you to take that into consideration as you formulate this bill. Thank you, and I'll stand for any questions.
Thank you. DSM, what's that acronym?
Mr. Chairman, Nick Reinecker, Inman, Kansas. It's the Diagnostic and Statistical Manual for Mental Diseases, I believe. It's a diagnostic tool that is used by some psychiatrists and clinical people to diagnose. However, there is no treatment modalities listed in it. There is forensic issues with it, and then other issues as well. Thank you.
Committee, any questions? Seeing none, we have no opponent testimony on this bill. And are there any other potential conferees in the audience? Seeing, Senator Faust-Godot, do you have a question?
Mr. Chairman, so those listening in, just a clarifying question for Mr. Robert Hutchins. So when this says the word license, so clarify when you don't need a license to carry and when you need this license that you were referring to.
This one?
Office of the Attorney General. I don't know that there are that many circumstances where carrying a license gives you more privileges than the constitutional carry in the state. There are some places that may try to limit it to people who actually have the license on a business-by-business choice. It also offers expedited review and purchasing firearms because it stands in place of background checks, I believe. But I think those are the primary differences in use in Kansas.
And a lot of it also goes to reciprocal agreement was for concealed carry in other states. Did you have something you wanted to add, Senator Clues?
No, I was just going to say being able, when you have that permit going to other states is the primary difference.
And you do have to, with the concealed carry, you do submit for background checks and do training and all. So it's that little, Jason, do you have something to add to that?
Mr. Chairman, just to point out that if you're under the age of 21, you have to have a license issued under the Act in order to carry a concealed handgun in Kansas. Once you reach age 21, then the constitutional carry becomes effective.
Thank you.
Okay, thank you, Robert. Any additional questions? Seeing none, thank you very much. We will close the hearing on Senate Bill 523. Committee, we will not meet tomorrow. We will have a bill hearing on Monday, and that's the end of our work